It is June 3rd of 2026, and this is the Court Gallery. Some court dockets are routine, and some are, well, this. We kick things off with a man whose DUI case is so old he simply lost track of it for 3 years. Then, a rideshare driver is so confident in his technology he tries to use his Uber app data to argue with a police radar gun. And you'll not be prepared for what happens when a simple truancy ticket for a second grader devolves into a live action custody war, forcing Judge DeSanto to become an unwilling family therapist right from the bench. From bizarre excuses to legitimately high-stakes consequences, we'll see that and more. And it all starts right now.
All right, let's take up the matter of Jameer Young.
Good morning, John.
Good morning. This is kind of an odd case in that it's almost 3 years old. The file number is 231446SD. Mr. Young has very minor criminal history. He got arrested here in 2023 for a drinking driving incident, which frankly was not real good. And we lost track of him for several years and caught up with him recently. He's here with his lawyer, Casey Strong. Ms. Strong, what would you like me to know?
Thank you, Your Honor. As the court already recognized, this case is from 2023. During the pendency, Mr. Young has not been in any trouble. He has been working and living his life. As this approach, he did take significant steps. He had a substance abuse assessment completed. He started following those recommendations. I will allow him to speak more to that. As indicated, we understand that the presumption in impaired cases is fines and costs, but understand and recognize the court's ability to overcome that presumption. I would like to note from Mr. Huff's report that Mr. Young was sleeping in the back seat and he woke up to officers outside his car in 2023. He took responsibility for this immediately, which is reflected in the plea agreement from the state. The recommendation is 2 days jail credit, 1 day to schedule 24 hours on the weekend. With understanding of the facts, I would ask the court to follow that recommendation, looking to the jail's limitations on scheduling and considering that as well. Thank you.
Well, you drove from where you live in Indiana to Grand Rapids, picked up your brother-in-law, and drove all the way back from Grand Rapids, where you went off the road south of Three Rivers on 131, nearly killed you and your brother-in-law. Ended up in a field. The facts are bad. Your blood alcohol is 0.15. Mr. Matt Huff prepared the screening report and points out some of the issues I just addressed. Mr. Huff, what's your thought here?
Well, as it's been stated amply so far, this case is strange. It's from 2023. It involves somebody who doesn't live in our county, who lives 2.5 hours away down in Converse, Indiana. On its face value, the case is pretty aggravated in the sense that it would involve the property damage accident where he left the roadway. Obviously, there's inherent risks when you're driving drunk, and this was a vivid example of what can go wrong. With that being said, Mr. Young appears to be taking responsibility. He wants to get his driver's license back. He wants to get his life on the right track to where he can do the things he wants to do, and that requires him to take responsibility for this action. So he has not been in any trouble since. He doesn't have a lot of extensive criminal history. I noted in the report, technically he qualifies for probation. I just don't think that it's really going to be feasible for somebody who lives 2.5 hours away. There's got to be a consequence for actions, even if they are 3 years dated. Otherwise, everyone would just take off.
The reason it's 3 years old is he didn't show up for his arraignment.
Right. Otherwise, everyone
blew off the arraignment, and then several years later, he calls and says, "Hey, my license is suspended." Well, I guess so. That's what restarted it. Now, he didn't show up for 3 years, but he did. I think he called us and made arrangements to come in. But the reason it's 3 years old is because he didn't show up.
Right. So I made a recommendation for some scheduled jail. He's worked at a position or at a Walmart distribution facility for a substantial amount of time. He takes care of his family. If that punishment is to be enacted here today, as far as the jail sanction goes, I think that the court could schedule that.
Well, Ms. Strong just told me something I hadn't heard before, that he's done some treatment and got some evaluation stuff. Did you know any of that?
I don't believe I was aware of that, but I'm open to.
I'll let Mr. Young speak to that.
Mr. Young, let's hear from you.
Yes, sir.
Go ahead. What would you like me to know?
Well, since this, I've taken the measures to obtain my driver's license. I currently hold a CDL within the state of Indiana. I had conversations with my pastor at my church regarding this and other matters that I'm currently facing, not me personally, but within my family. So I'm just really trying to take care of that.
All right. Well, there's, you said you got an evaluation.
I'm sorry, sir.
You got an evaluation?
Yes. I've talked to, besides of talking to the probation, Mr. Huff here, I had a conversation with my pastor.
All right. Well, as your lawyer says, 3 years have passed, but that's your fault. This was bad. I suspect you were doing some road beering on the way either up there or the way back. I don't think you drank 16 beers and drove all the way to Grand Rapids and all the way back before this accident happened at Zerby Road. But it was bad. You went off the road into a field and you're out there and your brother-in-law's out there in the dark. And then you didn't show up. I'm not going to do a probation. It is impaired, which in Michigan would allow you to keep a restricted license. We did get a bond posted, but I think it was a surety bond. Once upon a time, I had a file. I could open it up and I could see a bond receipt in it. Now I have to do a scavenger hunt. I think I set the bond at 500 cash or surety on a bench warrant. Now, when you came in, I canceled the bench warrant, so we don't have any bond money. There's a $300 fine, drinking, driving, expensive proposition. $125 of state minimum costs. $75 crime victims' rights fee and a $50 state minimum fee. There is a $255 reimbursement to the sheriff's department. There's $150 attorney fee and $100 screening fee. It all adds up to quite a bit. 300 plus 125 plus 100 plus 150 attorney fee plus 255 police reimbursement equals $930. I make that due in 6 months. Due by 12/3 with a payment plan. One day that you spent that night and an extra day for blowing off your arraignment. The guideline range was 5 to 7 days. But the reason this is 3 years old is because you just didn't show up. And then when there was a consequence, you did. 2 days jail credit, 1 day to serve. And I don't want to screw up your employment. We're going to schedule that at a time that works for you by the probation department. I don't know what this will do to your Indiana CDL. I don't make any prediction about what that's going to do to it. But if it was a Michigan, you would be allowed to drive to and from it in the course of employment. So I want you to go out with Mr. Huff, and I want you to go to the probation department. They're going to schedule when you're going to do this jail time, unless you want to just do it. Did you want to just do it this weekend? Or is it life too complicated?
I have a forensic interview tomorrow.
All right, I'll leave you and Mr. Huff to work out a date.
Just make sure you do it.
All right, we're back. I've titled this matter hearing on a special motion. The title of the case is People of the State of Michigan versus Ladislaw Visky, file number is 26371SL. Mr. Visky is present here with his lawyer, Mr. Luke Nofsinger. Also present is Abby Stoll from the prosecuting attorney's office. Defendant was charged in an original complaint alleging domestic assault that allegedly occurred on May 10th of 2026. The complainant was at the Brewers Hospital, and the investigation started from there. Sometime after that, the defendant was arrested for domestic violence. The matter was set for an arraignment, then it was set for a pretrial, and after some discussion, the prosecution filed an order of nolle pros. The actual Latin name is nolle proseque. I think it means no proceeding. Anyway, it's an order of dismissal. That was filed on March 26th by Gary Gabry, chief assistant at the prosecutor's office. It states, defendant has complied with all terms of the plea agreement. Prosecution moves to dismiss. So I signed it. I ordered the motion for nolle proseque is granted and the case is dismissed without prejudice. Bond is canceled and shall be returned to the defendant after costs are deducted. And the Michigan State Police and arresting agencies shall destroy the arrest records, biometric data, DNA profile as required by the statute. And that was indicated dated 26th of March. Mr. Vitsky came into the court a couple of times and in the middle of other hearings and inquired about this. And then ultimately advised him he was going to need to file a motion. He was not satisfied or content with the order and disagreed with the language. So Mr. Nofsinger has filed a motion to correct the nolle pros pursuant to 643(5)(a). And Ms. Stoll has filed a brief in opposition stating we meant what we said the first time. So, Mr. Knopfinger, what would you like me to know?
Yes, thank you, Your Honor. I recognize this is a very unique request, and it is rare to see a nollie prosecute before its entry by the court. We have a very simple request, Your Honor, is that the word plea be removed from or amended to be removed from the nollie, because it will not only affect Mr. Vitsky's immigration status. He is a lawful permanent resident, a green card holder, and the crime that was charged would be considered a crime of moral turpitude under federal law. And I came on to the case actually after it was dismissed. It's my understanding this was discussed to a certain extent. There was some hoops that Mr. Vitsky jumped through. He did, in fact, do that. And so for that reason, Judge, the plea will affect his immigration status, because the USCIS, which would process that, not only his review the status of his green card status, but then also adjudicate an application for naturalization. He also is a federal contractor, and this is affecting his employment for that same reason. Mr. Vitsky is actually relocated to Arizona, and he flew in just for this hearing. It is very, very important for him, Your Honor. I think that after reviewing the language in the nollie, that it is misleading to someone to read, to see that there was a plea agreement. Certainly, there was an agreement.
Well, all right. So what would you call it? Just an agreement?
Yeah, it was an agreement. No plea was entered. I don't think there's any.
Well, a plea of not guilty was entered.
Sure. In this context, it's misleading. He entered a plea of not guilty. Sure, if we want to say there was a plea of not guilty and then the case was dismissed. But in this particular context, it is misleading to read that he agreed to a plea. And so for that reason, Judge, and primarily, practically speaking, the USCIS, and this is where I get a little uncomfortable because
What is the USCIS?
Judge, that is the agency under the Homeland Security.
Well, I've had all these representations that has these ramifications, but I haven't seen anything. I don't know if you shared anything like that with the prosecutor.
Sure. I mean, one thing I was going to ask for, Your Honor, is if the court would be inclined to have an evidentiary hearing on this point. It's clear to me that a conviction for domestic violence would be a crime of moral turpitude. That's federal law. I can brief the issue further.
No, but you indicated that he's confident that it's going to affect his immigration status.
Mm-hmm.
Do you have a letter? Is there anything to the effect that this is going to have a negative consequence, or it's just a concern that he has?
No, I believe he's under the impression that it will.
But the impression how? Just what he believes, or there's something in writing someplace?
Yeah, would the court like to inquire, Mr. Vitsky?
Yeah, Mr. Vitsky, as I indicated, you had stopped me here in the courtroom once or twice in the middle of or after other hearings, and I wasn't even really able to address it. But who is telling you that this is going to affect your residency status?
Agency USCIS, United States Citizenship and Immigration Services. They do not provide letters. I have requested letters. They told me over the phone it is considered moral turpitude, bad character of moral turpitude, and my application will be denied based off of that, unless I have to wait 10 years to clear the record so I can reapply again. However, my current status is active for 2 years only. So it's either I have to finish my employment right now, I have to leave the country and maybe try 8 years later. But I have requested letters twice, and they told me they wouldn't be providing any letters.
Right,
and
but
stuff.
they're someone from the federal government is
Yes.
representing to you that.
Yes.
this is
On top of that, for my employment, I have received temporary clearance based on pending case right now, and the clearance to work with federal government is going to be revoked if I cannot resolve this matter successfully.
Is the fact that you've married an American citizen a factor in attempting to get permanent residency status?
Yes.
All right, so I'll take it at your word. You're not under oath, but that they've represented to you from the federal government that this would have a negative consequence on your application. All right, anything else, Lou?
No, I think that summarizes it.
All right.
Proposition, Judge. Thank you.
And when he first asked this, I said, well, I can't just wave my pen and make this go away. I said, you could use some legal help, and he got you to file an actual brief. The court rule that you cite, 6.435, is the one that has to do with correcting mistakes. Lord knows I've probably made my share of mistakes in court orders over the years, but there's a rule that lets you fix it. Prosecutor contends this isn't a mistake. It's what they intended. Ms. Stoll, what's your position here?
Your Honor, I seriously doubt that my use of the word plea in the nollie has any effect on the defendant's immigration status. If ICE is trying to get a hold of him, I would assume that it's because he was arrested for domestic assault on his wife. And that besides, the word plea is not synonymous with guilt. I define that from the Black's Law Dictionary in my brief. And I really don't think that the term or the phrase plea agreement should be given that much consideration. It's a generic phrase that's used and every day in our office. And I believe that also applies to cases where they're dismissed, not necessarily reduced.
I don't know as much of the facts as the prosecutor does. The prosecutor has the whole police report. I have an affidavit of probable cause that came with it, or a bond report. And they may not wish to give you any further relief. The police, Three Rivers Police, were dispatched to Three Rivers Hospital for a female that came in with a suspected assault. She was distraught and in an emotional state. She advised she was riding in the vehicle with her husband on US 131 near Broadway when he got upset and started to hit her with a closed fist in her arm. I could visually see redness and bruising started to form on her arm. She explained that it happened around 4:30 and the husband kept driving. When she got home, she jumped into the driver's seat, drove herself to the emergency room. She advised she thought her arm was broken. She sought immediate medical treatment from the assault. So that was what was used to set the bond. So you weren't acquitted. You didn't have a trial and were found not guilty. By the grace of the prosecutor, they asked you to do certain things and you agreed to do them. The matter was dismissed. That was part of a plea agreement. You pled not guilty. They agreed after that plea that if you met certain conditions, the case would be dismissed. If we take out plea, the word plea, defendant has been complied with all terms of the agreement. I don't know exactly what that means. It probably, as Abigail said, we use the word plea and plea agreement all the time. But when I moved from my old office to this office, I found about 3 copies of Black's Law Dictionary. And from time to time, we actually go back to it. Black's Law Dictionary defines the term plea as an accused person's formal response of guilty not guilty or no contest in a criminal charge. The word plea itself does not denote conviction or admission of guilt. And they contend that it is not an error, and they put the word in there intentionally, and it's their order. Now, it was without prejudice. I suppose we can withdraw the plea and go back to square one, but I don't think anybody wants to go down that road. So I appreciate your concerns. I don't know whether what somebody told you over the telephone is going to be cast in stone. But let's assume that you had entered into the prosecution's deferral agreement. There's a special statute, 769A, I think it is, which allows the prosecutor to defer and dismiss a criminal case. I can't do a deferral in a domestic violence case without the prosecutor's consent. But if they consent and I put you on the probation and you agree to the terms of the probation and complete all the terms, the charge is removed from your record as a criminal record of conviction. It would have actually been a conviction, but it's pulled back out of the system, including the fingerprints stay, but the conviction becomes non-public. This was more than that. They absolutely dismissed the case altogether. You did some terms which would have been similar to an agreement for a deferral, and they agreed to dismiss it, meaning your fingerprints are returned, your DNA is returned, and the case is removed from the system. And their position is that's as far as we're going to go. We believe you punched your wife in the arm and she went to the hospital. And if this isn't good enough, I don't know what else to say. That's their position. And I'm not going to correct a mistake that the prosecutor contends was not a mistake. They put the language in there on purpose. I signed it. I returned all your fingerprints, had the matter removed from the system, and hopefully that's enough. It is. If it isn't, there's a consequence to acts, and there's a very large consequence here. It's called a collateral consequence. It's outside the purview of the court. Well, anyway, I'll do an order denying your motion, and then you can say that. Yes. I don't want to hear anything you have to say. You're not the party in this case. You're the complaining witness. They agreed to those terms and conditions, I think, after talking with you. You don't have standing to give any input in the nature of this dismissal. So, all right. I don't think everybody's happy with this, but that's my rule. And I'll do an order indicating that the motion to alter the order was denied.
And the court calls case number 26 RO02063. This is People versus April Annette Hudson. That's you, Miss?
Yes, that's me.
Miss Hudson, you were present just a second ago when the court explained the nature of an informal hearing. True?
Huh?
Is that true?
True. Yes, I was in the courtroom. Yes.
Yes. So you understood the court's instruction that you must select from one of three options to protect your rights. Yes?
Yes. I kind of.
Thank you.
Yeah.
All right, Ms. Hudson, the citation before the court was issued on April the 9th of this year at 4:07 in the afternoon. You were operating a 2017 Ford black in color on 10 Mile Road, near Campbell in the city of Royal Oak. And at that place and time, you were cited for disobeying a traffic signal. Officer Carr's remark that shows on your ticket indicates westbound 10 Mile Road went around stop cars to proceed through red light. And that is the substance of the allegation, but it is simply an allegation. You may admit responsibility, Ms. Hudson, You can admit and explain, or you can deny responsibility and the court will conduct your trial. What do you wish the court to do for you?
Um, can I explain?
You can explain, but it has to be in one of those contexts. So you can accept responsibility and explain, or if you don't believe you violated the motor vehicle code, you can deny responsibility and explain under oath after the officer's testimony.
Oh, okay. I guess. I guess I don't know. Cause how much is that ticket?
Well, if you don't know, it's not a conditional circumstance, Ms. Hudson. The court can't be in a position where it's haggling with you. The court's the neutral here. Please raise your right hands. Do you both solemnly swear the testimony you shall give before this court shall be the truth?
Yeah.
Thank you very much. The officer goes first, Ms. Hudson, then it's your turn, Mr. Carr.
Your Honor, on April 9th, around 4 in the afternoon, I was westbound on 10 Mile approaching Campbell, at which time I observed a black vehicle ahead of me drive around stop cars and continue westbound through the red light, at which time I activated my lights, caught up to the vehicle, made a traffic stop, and made contact with Ms. Hudson.
Okay. And when you approach the vehicle to conduct a traffic stop, is the individual you recall present here in the array today?
She is.
Okay. Did you learn anything further during the development of your investigation and discussing this with Ms. Hudson?
If I recall correctly, she told me she really had to use the restroom, which is why she ran the lights.
Very well. Anything further?
No, Your Honor.
All right, Officer Carr. Ms. Hudson, the court turns to you. What would you like the court to know?
That's what I was trying to tell them, that I was using the bathroom, and then when I stopped, I waited for it to change. Like I went when it was like about to change.
I'm sorry. The court wants to make sure it understands everything you're saying. So you're saying you went when it was about to change. So you're suggesting the light was yellow?
No, it was like
Oh,
it was
okay.
red, but it was about to change. You know how you see the other side where you can see where it's about to change, like what color it is? Like
Mhm.
the other side you can see it's about to change. So it's about to change green. That's what made me like go, because I had to go to the bathroom like really
All right.
bad.
So
That was
so your recollection is it was red for both directions of traffic. And you had a personal emergency and that's what you did. Is that the court's understanding?
Yeah.
Okay. Is there anything else you want the court to know?
No.
All right. Thank you very much for your candor. Officer Carr, rebuttal testimony.
Your Honor, the problem with that intersection is the lights are timed differently. Northbound is going to have a green arrow to go west and green to continue northbound. The south light is in a different set of timing. There was also northbound vehicles traveling through with a green.
Very well. Officer, all things being equal, if the light were illuminated red for both directions of traffic, what would be your interpretation of the duty of the motorist at that point?
I ask what Ms. Hudson needs to wait till it's green to continue.
Okay. Thank you. If your testimony is complete, the court is ready to rule. Ms. Hudson, the way the court observes strictly the court rules and the rules of evidence for the protection of all parties is the officer had the burden, so he testified first, then it was your turn. He has the burden, so he gets a rebuttal argument if he chooses to make one. The testimonial portion is closed. The court first notes that civil proceedings are just that. They do not require a finding of guilt beyond a reasonable doubt. The burden of proof is a mere preponderance of the evidence. Secondly, the court wishes to note that after working in and around the courts in the state of Michigan for the past 40 years, the court wishes to always believe that the parties are proceeding in good faith based upon their best recollection and perception of the events. Lastly, the court observes that it does not review any civil, criminal, or other histories or records of motorists when it manages a traffic docket. Each and every case is judged on the merits put forward in evidence only. The court does believe that Officer Carr's burden has been met. So the court is finding you responsible, Ms. Hudson. Historically, the fine for that particular offense is $150. Given that you had a distress circumstance, the court sees fit to reduce your fine to $120. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 7 days. Or if you wish to take up an appeal, post the $120 in cash within 7 days, and the matter will be placed on a formal hearing docket, and the city would be represented by a city prosecutor. So $120 is a bond or a fine within 7. That closes your case. Please drive safely. Thank you. This is case number 26, RO 01929. People versus Omar Gamal Hussein. Mr. Hussein, are you there?
Yes, sir. I'm here.
Are you able to activate your camera?
Yes, I will. It's just
All right,
not very nice background, but
you're doing fine, sir. Mr. Hussein, you were present earlier when the court explained the nature of an informal hearing. True?
yes,
So you understood the court's instruction that you must select from one of 3 options to protect your rights. Yes?
yes.
Thank you, Mr. Hussein. The citation before the court was issued April 4. This year at about 2:45 in the afternoon, you were operating a 2023 Toyota black in color on Stevenson Highway at or near 4th Street in the city of Royal Oak. And at that place and time, you were cited for exceeding the posted speed limit of 35 by a minimum of 1 to a maximum of 5 miles over. Officer Carr's remark, which shows on your ticket, indicates a margin of speed from his radar capture of 20 over the 35, but he indicated he wished to, on the ticket, just simply write this for 1 to 5. Regardless, Mr. Hussein, today is your day in court. You may admit responsibility, you can admit and explain, or you can deny responsibility, and the court will swear the parties and take testimony. What do you wish the court to do for you?
If I admitted responsibility, the court would also be able to dismiss the case at any point if I provided some evidence that might not be.
Well, if you have evidence that you believe indicates you're not responsible, then that would not.
I do have an evidence, but I'm not really sure if that would be taken as a valid evidence.
The court can't give you advice either. So
yes, so I would admit no responsibility at this point.
Very well. Please raise your right hands. Do you both solemnly swear the testimony you shall give before this court should be the truth?
I do.
Yes, I will.
Thank you very much. The officer goes first, Mr. Hussein. Then it's your turn, Officer Carr.
And on April 4th at 2:47 in the afternoon, I was operating stationary speed enforcement on Stevenson near 4th, at which time I observed a black vehicle southbound on Stevenson. I activated the front radar, received a speed readout of 53 in the posted 35-mile-an-hour zone, which time I pulled out, initiated a traffic stop, made contact with Omar. The radar passed the internal test before and after the shift, and I've been radar certified since 2004.
Thank you very much. Officer Carr, is it your testimony that, as you recall it, no other large metal objects or secondary vehicles were in your capture cone?
And that area is a nice clean shot of southbound traffic.
And no indication of radio frequency interference, anything of that nature?
No error messages beginning, during, or after the shift.
Very well. Thank you so much. And the court turns to Mr. Hussein. Mr. Hussein, what do you want this court to know?
So I was doing Uber at that time. I had a passenger in the back seat. I do have a tablet, and the passenger also can monitor the trip, and I also have it on my front infotainment system on the dashboard. So the system does automatically trigger a red tag when if I exceeded the speed limit. Mm-hmm. And it did not trigger that. It did not notify the passenger. The tablet screen does not show the red tag, and I do have a passenger in the car with me. So it's actually better for me to drive slower than. I also have another after the trip. I also have a screenshot. So because I do get rating from Uber, I get 5% more income if I per trip if I have a score over 85. So I always try to drive a little bit slower, or at least because I'm being monitored during that trip. So I would like to share um, the screenshot of the
You can
trip.
share your screen if you wish. That's fine.
Okay.
All right, you're
So
live. Mhm.
yes, so this is the trip right here. It shows the time. It was at 2:39 p.m. So around that time, and that's where I picked up the customer from 14 Mile, and I took her to Ferndale, and that's the route of the trip. It does show, just to prove that the system is working, it shows that I was speeding here. There was a speeding event, and it shows a dot right here at Clawson right before I get to 75. But it did not detect any speeding at that point where I'm not really sure where the police officer pulled me over, but I think it's somewhere here at the where it says Royal Oak where the K is. That's where I emerged from the 75 into the service road, and that's where he pulled me over. Um, and I think that's where it's supposed to show that I was speeding, since the speed changed from 70 to 35, but it did not show that.
Okay. All right. The court appreciates that exhibit. Mr. Hussein, is there anything else you want the court to know?
I just want to. I mean, I just took this. I'm just looking for. Also, I was working on a Sunday or a Saturday. This is a supplemental income for me. Getting points does affect me long term because it's just going to raise my insurance rate.
Understands, Mr. Hussein, but we're now in a contested posture. So what, if any, sanction there might be is really not relevant to the court making a finding of responsible or not responsible. So the court simply has to make a factual finding based on evidence.
Yes.
Is there anything else you want the court to know?
I just want the court to know that we rely on technology every day. I do understand that there was a sign that says 35 miles. Even if I was speeding and I didn't notice it, the system that I'm using did not notify me that I use it. But it's still we still use technology every day. I don't know how the radar works, and the police officer just mentioned that he's been doing this since 2004. But and maybe like I don't know if it was like calibrated at the time, or I don't really know how it works on his end. But I just have a proof, and I just wanted to present it to the court that I was not speeding or
And the court
intentionally.
and the court appreciates your exhibit, and the court did take ample time to review that. Is there any other? You've summed up your testimony a couple of times. Is there anything else you want the court to know different from what you've already said?
No, Your Honor. Thank you.
All right. Thank you so much. The court turns back to Officer Carr. Any rebuttal testimony?
Your Honor, my concern is the map does not zoom in very far, and our in-car police maps, if you're on Stevenson, the maps believe that you are on I-75. So doing 53, the app is not going to believe you're speeding if you're on the freeway, which is 70, so it's not going to alert that he is speeding. Our maps believe we're on the freeway when you're actually on Stevenson at times.
Anything further, Officer Carr?
No, Your Honor.
Okay. The court has heard the testimony of both parties.
Excuse me, Your Honor. Your Honor, can I just?
He has a right to rebuttal.
I'm sorry.
He has the burden of proof. He went first. You testified. Then he has a right to rebuttal. This court strictly observes the rules of evidence and the court rules. So it is not an unlimited number of bites at the apple. The testimony has been received by both parties. The court first notes that the burden of proof in a civil matter is a mere preponderance of the evidence, characterized as the featherweight test. Secondly, the court always wishes to believe, after 40 years working in and around the courts in the state of Michigan, the parties are always proceeding in good faith based upon their best recollection and perception of the events. And lastly, the court has absolutely zero idea what Mr. Hussein's driving record might look like. The court's judging this matter simply based on the evidence before it. In specific, the court would cite People versus Fry and People versus Dobert, which are two tests for admitting technological evidence into a forum. These tests are what is called the scientific test for reliability. And this court is aware that radar has been admitted into court in all 83 counties in the state of Michigan. The officer also testified about the operational status of the device. The court does not have any familiarity with what it sees before it on the shared screen, but the court does believe that the burden of proof has been met. So, Mr. Hussein, you are being found responsible. This ticket is not a terribly expensive one. The fine is $130. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. The court marks that due within 7 days. If you wish to appeal, you can post a cash bond in the amount of $130 within 7, and the case would get placed on the formal hearing docket, and the city would be represented by a city prosecutor. So $130 as a bond or a fine within 7. The court does appreciate you being prepared and your professionalism. Good luck to you, sir.
Would I get a point on this ticket?
The court does not assign the points, Mr.
Oh.
Hussein.
Oh.
The judgment has been rendered. The traffic clerk will log that in. What, if anything, Secretary of State Joycelyn Benson does after that is her business and her bailiwick. Good luck to you. Calling case number 26, RO 02235. This is People versus Ryan Matthew Tate. That's you.
Yes.
Mr. Tate, you were present a bit ago when the court explained the nature of an informal hearing. True?
True.
So you understood the court's instruction that you must select from one of 3 options to protect your rights, correct?
Correct.
Thank you. Mr. Tate, the citation before the court was issued April 14th at 18 past 10 in the morning. You were operating a 2024 Ford Mustang, blue in color on Catalpa and near Main Street, so you Royal Oak at that place and time.
Yes.
You were cited for expired plates. When Officer Carr ran that plate, it came back expired last summer in July.
Correct.
Looks like every year during the All-Star break, you also have to accept a new birthday.
Yeah.
So
Exactly. Do you want me to go ahead with my selection, or?
Well, stand down for just a second. So
Okay.
you have your 3 options. You can admit responsibility, you can admit and explain, or you can deny responsibility and the court will swear the parties and take your testimony. What would you like the court to do for you?
Admit and explain.
Very well. So you're confirming to the court that on the date of question, you were operating a motor vehicle in the city of Royal Oak with a tag that had expired July 29 of 25, correct?
Correct.
All right. Do you have a new registration?
I do. I realized that I left it upstairs before I started, but I didn't want to be gone when you guys called my name.
You're fine. If unless Officer Carr's already run that, you can go get it.
Okay. Yeah. Give me about 1 to 2 minutes here.
Don't rush. Don't get injured. Okay.
Okay.
And then you're going to need to take your filter down so the court can clearly see it. Okay.
Oh,
On your
absolutely.
device.
Yes. Yep. One
All
moment.
right. Thank you. Did you hear motorist Stoddard refer Officer Carr as very polite?
Didn't know that. I noted that. It's on the record.
It is a matter of record now.
I'll take a copy.
It is.
She was one of those, I would have impeded her, but that TIA detail does not allow that.
Okay. Which is why we spend a considerable amount of time with people with book reports from Officer Urich's mobile device TIAs.
Correct.
Yes.
It'll say TIA on the top of all those tickets.
Okay. 1 second. Let me see if I can.
You're doing fine.
This filter off. Okay. And then I'll try to put it up. So it expires now July 29th, 2027. I don't know if you can.
Bring that in a little closer. Say your name.
Yep. Ryan Matthew Tate.
Perfect. Officer Carr?
Yeah, it shows renewed, Your Honor. Can we dismiss the ticket, please?
Very well. Motion to dismiss, Mr. Tate. So I would suggest that in July of 27, you're going to know what to do, and every July thereafter.
Yes. This is the only time it just busy summer slipped my mind. Didn't realize I hadn't done it. I appreciate it. Thank you so much.
You're doing just fine. Take care.
Yeah, you too. Bye.
That was quite the gaming setup.
Yeah, that was really
That
elaborate.
was impressive.
Calling case number 26, RO02094. This is People versus Noble Thomas.
Yes, sir.
Mr. Thomas, you were present earlier when the court explained the nature of an informal hearing. Were you? Or is this the first
No,
time you've
this is-
been admitted to
Yes,
court?
sir.
Okay. Mr. Thomas, that's fine. Today's the date and time set for your informal hearing. This is a civil proceeding. It is not criminal. No one's going to
Okay.
jail today on this traffic ticket, but it is considered serious enough that the officer issued the citation on the date in question. You will be required to make a selection from one of three options and three options only in the protection of your rights. You may, if you wish, simply admit responsibility. The court will attach a fine between 0 and the maximum, and that will close your case. You may also, if you wish, admit responsibility, but with an explanation that you believe mitigates your circumstances. Your third option is to deny responsibility. That is absolutely your right. If you do so, the court will conduct your trial forthwith. The officer will testify first. He has the burden of proof. Then it is your turn to testify. Then the court makes the finding of responsible or not responsible, but that is based upon the civil burden of proof, which is a mere preponderance of the evidence, otherwise known as the featherweight test. We are not in criminal court, so the heavy burden known as guilt beyond a reasonable doubt does not apply. So the citation itself indicates that on April the 11th, at approximately 8 in the morning, you were operating a 2009 Toyota, white in color, on Interstate 75 at a near 11 Mile Road, City of Royal Oak. And at that place in time, you were cited for speeding 26 miles or more over the posted speed of 70. And apparently this is what they refer to as a LiDAR capture. So laser radar versus conventional radar. So you may admit responsibility, you can admit and explain, or you can deny responsibility, and the court will swear the parties and take your testimony. What do you wish the court to do, Mr. Thomas?
So
Court's having
what
trouble hearing
happens if I go with the first option?
I'm sorry, sir. Say that again.
What happens if I choose the option 1? What if I choose the first
What
option?
if you choose the first option?
Mhm.
Well, then the court just attaches a fine that it believes is appropriate for the circumstances. The court takes a tremendous amount of pleas every week, 52 weeks a year. Usually someone has some form of an explanation, but it is your right and privilege to use any one of those three options. So
The
you may admit
explanation.
responsibility, you can, please hang on. You may admit responsibility, you can admit and explain, or you may deny responsibility, and the court will swear the parties and start your trial. What do you wish the court to do?
If I were to choose to admit it, how much points do I get?
The points are not the province of the court, Mr. Thomas, and the court's not here to haggle about points or fines. The court is painstakingly observing your rights and protecting them as well as it can, but the court must take a plea first before it is going to tell you what, if any, consequence there might be. So I again ask if you wish to admit and explain, or deny responsibility.
Admit and explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed of 70 on the interstate by at least 26 miles, correct?
Yes, sir.
Thank you. The court is grateful for your honesty. Mr. Thomas, what do you want to tell this court?
So every day I take the route in the morning. Usually every weekday, the road is so congested. I drive around the speed of 30 miles per hour most of the days. That given Saturday, the road was very empty, and I was behind a couple of cars in front of me, which was going at that speed. And at the point where the officer was taking the speed using the radar gun, it was a downward slope on a curvy road. So I was behind a couple of cars, and I was following at that speed. I lost track of the speed at that specific point. Usually, I'm very cautious about the speed. I'm always under the speed limit. But that day, I was going with the traffic, and unfortunately, I was the car uh, caught on the radar gun, I believe. And every other day, I usually drive on 75 at the speed in that zone at 35, less than 35, 40 miles per hour because of the traffic. That given day, it was very empty road, and uh, I lost track of the speed because there was other cars in front of me, and it won't happen
Okay.
again from my end.
Thank you, Mr. Thomas. The court appreciates your honest remarks. Had this been April 10th, a work day rather than a Saturday, we could be having this conversation in the hospital, in the funeral home. That is blazing speed, okay? Especially right in that area through the mixing bowl, so to speak. There's an awful lot going on. So the court's going to put that to the side, Mr. Thomas. Officer Carr, anything you want to share?
Your Honor, all I would like to add is obviously laser is vehicle specific and there was no other vehicles at 96 miles an hour.
Thank you. With that, the court has taken the plea and heard the explanation of the party. Your honesty counts for something, Mr. Thomas. The court doesn't have any authority to add or subtract points, but what the court can do is offer some relief in terms of that fine. So your fine today is going to be $175 payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30, and that is due within 14 days. That completes your hearing. Please slow down. Do you have a family? Do you have children?
No, sir.
Okay. Slow down for them if for no one else. Okay. Good luck to you.
Court does call the cases of the people versus Anthony Holston.
Morning, Your Honor. Raymond Cookville.
Conrad Silver on behalf of Pittsfield Township.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Holston in all matters.
And Mr. Holston, could you state your name, please, sir?
Anthony Holston.
Thank you. What are we doing?
There are three forms, Your Honor.
Are there? Got it. I have.
You want for all the township cases as well as one for the state cases.
I have two files marked for please. Is that right?
Yes, that's correct.
Okay. In the case ending in 0070, the court's understanding that he's going to plead to the charge of trespass, 30-day offense. Upon his successful plea to that charge, don't you guys set this up? Okay.
The other four township cases would be dismissed, Your Honor.
Right. I would have the case ending in 0020, 0021, 0069, and 0067 would be dismissed.
That's correct.
Yes, Your Honor.
So those four would be dismissals upon his plea to that charge. The other matter, case ending in 0800, going to plead to the charge of retail fraud, second degree, the 1-year offense. Upon his successful plea to that charge, counts 2 and 3 in this case, as well as the case ending in 798, would be dismissed. Defendant in that case is agreeing to pay restitution on all counts, including dismissed counts, and the prosecutor will recommend fines and cost and restitution. Now that I've sorted all those files out, that's the court's full understanding of the agreement.
As it relates to the state's cases, that's correct, Your Honor.
As for the township cases, that's correct.
As to all cases, that's correct, Your Honor.
All right, very good. All right. Sir, can you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again, please.
Anthony Holston.
All right, starting in the case, ending in the township case. Sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges, but in that case, you're going to be pleading to the charge of trespassing. That's a misdemeanor punishable by up to 30 days incarceration, a $100 fine plus court costs. You understand that, sir?
Yes.
In the other case, you're going to plead to the charge of retail fraud second degree. That is also a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
To the charge of trespassing, how do you plead?
Guilty.
To the charge of retail fraud second degree, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial in either of those matters.
Yes.
You have executed on your behalf after going through it an advice of rights form, is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand you're giving up all of those rights, including the rights under paragraph 5, which are the trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
All right. You're not on probation and you're not on parole. Is that correct, sir?
No, sir.
Oh, well, we did that wrong. You're not on either one of those. That is correct.
Right. I'm in prison right now, sir.
You're incarcerated. That's what. Yeah, right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No, they haven't.
You're doing this voluntarily and of your own free will.
Yes.
And also because you believe that you're guilty of these offenses?
Yes.
On the date of starting with the trespassing case, December 27, 2024, location of 3145 Ann Arbor Saline Road, Pittsfield Township, Washtenaw County, State of Michigan. Were you on the property of Meyer?
Yes.
Had you previously been told that you were not welcome on that property and that you could not enter that property?
I don't really remember, Your Honor, but if they say I did, I'm sure they did.
Oh, well, we're gonna have a. So you don't recall being told not to go on that property?
I mean, from where? From the hospital or what?
No, this was at the Meyer on Ann Arbor Saline Road. Well, when was the date? You know what? Let me do it this way, sir. Because I think one of these cases leads. No, it doesn't. So at the 3145, you don't recall whether or not they told you not to go onto the property. And if you don't recall, that's okay, sir.
I mean, yeah, I vaguely remember. I mean, yeah.
Okay, let's try this. Let me go to the other case, okay? And then can you, if it's acceptable, can somebody send a police report on that one on the trespass? And I'll try to get it done, but get it done as a no contest.
I will try to send both.
Try to send it over. Okay.
Send it over right now, Your Honor.
So let's do this, sir. On December 22nd, 2024, location of 3825 Carpenter Road in Pittsfield Township, that also being a Meyer. Did you go into the store on that occasion, sir?
Yes,
All right. Did you try to take items from the store without paying for them?
yes,
All right. And the store was open to the public at the time that you went there?
yes,
You didn't have anybody's permission to take any of that property, did you?
no,
And the property that you took was property that Meyer had offered for sale?
yes,
And had you previously been convicted of retail fraud in the second degree back in the 62A District Court? I don't have a date.
I believe January 26th of 2018 or January 9th, 2018, both.
2018 or 19?
Both,
Yes.
both 20, it's either January 26th or January 29th of that year.
Okay. Do you recall being convicted previously of retail fraud second degree, sir?
yes.
All right. So I have that one.
And I'm sending the police report right now, Your Honor.
All right.
Sorry about that.
Sir, we're trying to so that we can resolve the trespassing case. We're having the police report sent over. My understanding is that you would be changing your plea to a no contest plea.
I mean, yeah, I mean, if that's acceptable, I mean, I can't say to you that somebody told me on that particular time because what's going on with that is that I'm not from your county. So I got stranded there for 2 weeks and that's what all this stuff is. So I don't know if that was the first time that I went there. You know what I mean? Like, I don't know if that was the first time that I went there and committed that retail fraud that somebody told me not to be there. I don't know what date that was. So I can't really honestly say to you that they told me what that was because I'll be honest with you. I went in there a few times.
Okay, I got you. And that actually, Mr. Holson, that all makes sense. I get it. So if you change your plea to a no contest plea, that would mean that you're not further wanting or desirous to contest this charge of trespassing. You understand that, sir?
Yeah, I'm not contesting it. Yeah, I'm sure if they said that I did that they told me, I don't think that they're particularly lying. I just don't recall them telling me that I wasn't supposed to be at that particular time.
Sir, I understand all of that. I'm just trying to get this done. So if you're going to plead no contest to that charge, you understand that all the rights that I indicated to you before would apply to a no contest plea as well as a guilty plea.
Yes, I do.
All right. And you understand that upon pleading no contest, that the court would treat you the same for purposes of sentencing as though you had pled guilty. You understand that, sir?
Of course.
All right. And counsel, the court has been provided Pittsfield Township Department of Public Safety report for their case 24-21532. Any objection to the court reviewing that report?
No, Your Honor.
All right. And Mr. Holson, just as a formality, to the charge of trespassing, how are you pleading now?
No contest.
Thank you, sir. And the court is accepting it based upon a review of that report. The court does find that there's a sufficient factual basis. I would indicate that based upon the court's review of the police report that the defendant doesn't remember. There's also an indication that the time of this offense that he was highly intoxicated to the point that he was taken to the hospital at that time. So, sir, I do have to, until the court does find there's a sufficient factual basis, Sir, I do have to advise you, if we do, between the time of my acceptance of your pleas and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you will not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir, I do.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Statement.
No, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right. In the case ending in 800, which is the state case, the court will accept the defendant's plea to count 1. Counts 2 and 3 in that file are dismissed, as well as the case ending in 798 is dismissed. In the other matter, court having found a sufficient factual basis, the court will accept the defendant's no contest plea to the charge of trespassing, and cases ending in 0020, 0021, 0069, 0067 are dismissed. Are there going to be issues of restitution on these?
Very minimal.
There's no restitution in the township cases.
On the state case, it's going to be a very minimal amount. I believe that half a bottle of Fireball was drank by the defendant as part of that offense, which obviously they weren't able to recover, and I don't know the value of that. So it's a
half a bottle of Fireball.
I was going to ask,
well, how much does that cost, Bukovich? I mean, okay, that was wrong. I just thought I'd ask you. Maybe you knew.
I don't drink Fireball.
Yeah, okay, fine.
Court's inclined to leave restitution open for 30 days.
Yeah, but why don't we do that?
Yeah.
All right.
I was in custody for immediate sentencing. My client's been in custody since July 2025 with an estimated release date of November 2027. And I know Mr. Seward indicated he has no objection to immediate sentencing in the city.
That's correct.
All
In
right.
the township matters, I have no objection to immediate sentencing.
Mr. Olson, anything you want to say before I impose sentence?
No, sir. I actually went to rehab after these incidences, and I had a warrant come up, and actually that's why I'm here right now. So I'm actually trying to get. I've completed both my classes that were required for my parole stipulations. I completed ASAT here in the prison. I'm just trying to get. I'm trying to get my life back in order, and alcohol has been my number one legal problem, source of my legal problems. So I'm really trying to get that squared away and understand why that it is that I keep going back and doing the things that I don't really want to do, and doing these, idiotic things like going in and stealing bottles of Fireball, that I don't do sober. So I just want to say that I'm sorry. You know what I mean? I there's really no more I can say. I got a problem and I need to deal with it, and I need to seek help for it. So that's what I'm doing right now.
All right. You'll get there. On the township case, I'll impose the state minimums of $125, 30 days incarceration, credit 30 days served on that case. On the state case, I will sentence the defendant to fines and cost of $125, which would be the state minimums, and 365 days credit, 365 days served. All right. Then you're all set, sir.
Okay, thank you.
Okay. Thank you. This case. Court does call the case People versus Gregory Peterson.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Kyle Thompson appearing on behalf of Gregory Peterson, who stands to my right. Greg, could you state your name for the record?
Greg Peterson.
I'm almost afraid to ask, but I have a plea form. Are we doing that?
Yes, we are.
Okay. The plea form indicates that he's going to be pleading guilty to the charge of failure to report an accident, the 90-day offense. And upon a successful plea to that charge, count 1, as well as the citation of careless driving, would be dismissed.
And that is correct, Your Honor.
That's correct, Your Honor.
All right, may I have him sworn?
Right here, solemnly sworn to affirm the testimony you're about to give, the whole truth and nothing but the truth self be God.
Yes.
State your name.
Greg Peterson.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of failure to report an accident.
Yes, Your Honor.
That is a misdemeanor punishable by up to 90 days in jail and a $100 fine plus court costs. You understand?
Yes, Your Honor.
Understanding that, you still wish to plead guilty
Yes, Your Honor.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form. Is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights that are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense.
Yes, Your Honor.
April 26, 2026, at the location of westbound I-94 in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Were you involved in an accident?
Yes, Your Honor.
All right. What happened?
I was going into the opposite lane and I accidentally bumped into another car and then
That's fine. Did you, after you had that accident, did you immediately stop and report the accident or drive to the nearest and most convenient police station to report that accident?
No, I did not report that to the police.
All right. You did neither, right? I asked it badly. Did you go to the nearest and most convenient police station to report that you had an accident?
No, I had not.
Did you stop and offer identifying information about yourself or render any assistance which is necessary to the other vehicle?
Yes, I did.
It gets tricky here, Judge. He did communicate with the other driver. There was some words that were exchanged and then got back in his car and left the location. The other driver then contacted the police. There was not an exchange of information.
That's okay. So you did contact the other driver, right? In some way.
Did have a conversation, yes.
Okay. And but you didn't give identifying information about yourself, did you?
Not in that circumstance.
Okay. And you did not offer or assist way to render any assistance if it was necessary.
Not during the incident, Your Honor.
Okay. Well, when you say the incident, not afterwards, you didn't do that, did you?
Well, what happened was I got out of my car. He came over immediately, kicked a dent into the side of my car, punched me in the face and kicked me. So I got back in my car and I left. Must I bring that up?
It's, but Judge, he was.
It's going to be a day, isn't it?
Was contacted.
Counsel approach. No, it's okay.
Was contacted by law.
All right. Court's going to briefly pass this matter. He'll explain why.
Okay. Thank you, Your Honor.
Thank you. Okay. I'm afraid to call it. Court recalls case People versus Gregory Peterson.
Morning again, not Arraignment folks for the people.
Good morning, Your Honor. Kevin Thompson appearing on behalf of Gregory Peterson. Stands to my right. Greg, please state your name again for the record.
Greg Peterson.
All right. My understanding is that he's changing his plea to a no contest plea.
That is correct, Your Honor.
All right. And the basis for that is I'll indicate a lack of memory as to things, and I think it's appropriate in these circumstances to accept a no contest.
That is correct, Your Honor.
So you understand that a no contest plea means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
And you also understand that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. All the rights I explained to you apply to a no contest plea. You understand that, sir?
Yes, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest, Your Honor.
All right. Court has received and reviewed Michigan Department of State Police report for their case number 3421-26. Any objection to the court having reviewed that report?
No objection.
The people, Your Honor, may I make a brief record as it relates to that report?
Yes, sir.
Your Honor, that report was furnished to the people this morning and promptly forwarded to defense counsel. I've spoken with defense counsel. My understanding is that he's had an opportunity to review it fully. I just want to make sure that was clear and on the record for the purpose of this plea, given the recent disclosure of that report.
And that is correct, Your Honor.
That is correct. All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of this offense. Sir, I do have to apprise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to set aside your plea, and the court would not be bound by any sentence evaluation or record. You understand that, sir?
Yes, Your Honor.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
None from the people?
None from defense.
And have I complied with the court?
Yes, Your Honor.
Yes, you have, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Thank you. Yes. Defendants referred to probation for a pre-sentence investigation and report and consideration of any restitution.
Oh, just restitution.
Sentencing in this matter will be
July 8th.
July 8th, 2026, 9 a.m. Bond will continue. All right, sir, on your way out, if you can stop at my probation department so they can start that process.
Yes,
I should also indicate that ticket number 264686-364 SI is also dismissed. Thank you
very much, Your Honor.
Thank you.
Thank you.
Court does call the case People versus Nicole Henderson.
Your Honor, Arraignment folks for the people.
Your name?
Nicole Henderson.
You are before the court on a misdemeanor complaint that alleges that on or about April 12, 2026, location of Gulfside Road near Washington Road, that you committed the offense of operating while intoxicated or impaired, second offense. You understand that, ma'am?
Yes, sir.
That is a misdemeanor punishable by up to 1 year in jail, $8,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized or forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, ma'am?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
Public defender case.
Brown appearing on behalf of Ms. Henderson, waive reading stand, press adjournment.
Depending on every way from a reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for
June 17th.
June 17th, 2026, 9 a.m. As to bond.
May I approach, Your Honor, with the prosecutor?
I would also ask to approach, Your Honor.
Yes, you may.
Thank you. Just listen.
Record should reflect we've had an extensive bench conference in this case, trying to figure out the defendant's record. My understanding, first of all, that there is, as to her bond, that there's a prior offense in 2022. There is a current pending drunk driving from I think it was 2025.
Correct.
2025. Out of that, and this becomes important, that case is still open. There is also, from, I believe, that offense, an implied consent violation. And out of that implied consent, her license or driving privileges in the state of Michigan were suspended from the date of, I just want to make sure I have the dates correct, but
July 20.
From July 12th, 2025 to July 11th, 2026. So as we sit here today, her driving privileges are suspended. I then have that. So in April of this year, this alleged offense, she was issued a 625G, but she cannot drive on that 625G because of the implied consent. She had no license at that time. At the time that this offense allegedly occurs, she also then has an open drunk driving case out of another jurisdiction and has the prior. And then she is here allegedly in this case with a 0.235 blood alcohol level. Mr. Brown, is there anything you want to say on behalf of your client regarding bond before the court fixes bond?
Your Honor, she's employed at General Motors in Lansing. She has a 4-year-old daughter that she cares for. She works from 10 p.m. until 6 a.m. I've mentioned sidebar that she does have a prepaid, pre-planned trip before all of this. And I'd ask the court to consider a reasonable bond in this case so she can save her job and take care of her 4-year-old. A scram monitoring device.
Anything from people?
Your Honor, not to recount everything that was discussed at the bench, I have significant concerns for this defendant's ability to remain sober, compliant with her bond conditions. I also have concerns about her returning to court at future dates, given the multiple warrants and given that she knew that she had those warrants at the time of this offense and told the officers essentially she was on the run from those warrants for reasons discussed at the bench, which again, some of those are private. I'm not going to get into on the record, as well as those reasons. I would ask this court set a relatively significant cash surety bond with, if the defendant were to post that bond, scram and GPS tracking tethers in case she does fail to appear, we can at least know where she is at that.
However, standard conditions, including no assault behavior, possession of any weapons, firearms, ammunition. It will also indicate that the defendant is not to possess and or consume any alcohol, recreational marijuana, or any illegal drugs. You do understand that, ma'am?
Yes.
I am going to set, I consider, given all of those circumstances, that the defendant is a significant risk to the public as well as to herself, because she cannot stop drinking and then operating a motor vehicle. It just seems at this point she is fortunate that she hasn't taken somebody out. She's a 0.235 at this instant, with a pending drunk driving and a prior, all occurring within the last 7 years. She's not supposed to be driving because she doesn't have a license, because she didn't take a test on one of these occasions. And the only license that she would have would be a 625G permit, which she can't drink and drive on. She's not supposed to be drinking and driving. Since I consider this defendant to be a significant risk to the public, and we can try to figure it out, her bond is set in the amount of $1,000 cash surety bond. The defendant is remanded. She must be placed, if she posts that bond, on a scram tether and a GPS tether prior to her release. The defendant's remanded.
Court date?
Thought I gave you one. June 17th, 9 a.m.
Thank you.
Location track.
Let's go on the record in the matter of the City of Wyandotte versus Rachel Duncan. 26W97295. Good morning. Your name for the record, please.
Rachel Duncan.
All right. And so, ma'am, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right. And so, ma'am, you've received a citation today regarding mandatory school attendance, correct?
Yes.
And you spoke with the prosecuting attorney, and the prosecuting attorney has indicated you're going to be pleading responsible, correct?
Correct.
And I also understand that the child's father is here and would like to address the court. All right. And so, ma'am, as to the charge of mandatory school attendance, how do you plead?
Responsible.
You've got, and you understand that you have the right to have a contested hearing in this matter, and by entering into this plea, you will not have that contested hearing.
Yes.
And you also understand the possible penalty as a result of your plea.
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And so, ma'am, tell me what's going on, why your second grader missed 27 and a half days of school.
So I did speak with the school.
Sir, stop. I don't know who you're mouthing your comments to. Stop.
I did speak with Garfield Elementary regarding this situation because in the beginning of the year, my older daughter goes to the high school, and I was having a difficult time. They start at the same time. I was having a difficult time taking the older one to the high school. Yes, the high school and Garfield Elementary started exactly the same time.
Did they change the time that the high school starts?
I don't know, but I believe it's 8 o'clock, and it's the same at Garfield Elementary.
Garfield's 8:05, but I thought the high school started before 8 o'clock.
We were told that Garfield is 8 o'clock on the nose. So I don't know if anything's changed on her, but I didn't understand that, to be honest.
Couldn't you drop off your older child at high school at 7:45 and then drop off your...
That was essentially what was happening. I was getting stuck in the school traffic and getting out of the high school. I also have a 1, so he's also there with me as well. So then I was taking the older, the second one then to school, and she was usually 5 to 10 minutes late. We did move out of Wyandotte in December, so we live in River Rouge now. And it takes me about 15 minutes to get there. So between the school traffic in the morning, there were just several days when she was late. And for every 3 lates, it's an absence. And as I mentioned, we moved. So since last summer when we were here, Your Honor, for our, I had a case dismissed against me. And since we had this situation happen last year, that situation is still ongoing, even though it's closed against myself. I'm still pursuing it. Since that happened last year, my daughter's been having a hard time with like sleep and emotional things that we're working toward. So she was greatly affected by what happened, and we ended up having to move. And so now, and moving forward, my older daughter has a ride, and she's also considering virtual school because she's not really enjoying the high school. And then that means then I just have one child to take, and this was effective as of April. I bet my older daughter had a ride, so now it's only been a couple months.
Okay, but I'm still not understanding how you couldn't have gotten your older child to school if you realized that you were stuck in the drop-off lines.
Yes,
why you wouldn't have gone earlier to drop your child off to the high school and then get your daughter to the elementary school.
I do understand having a toddler that is not interested in participating in this situation makes it very, very difficult. He has to be woken up just to be able to take them to school.
Oh, hold on.
Every single day.
Ma'am, many people have many ages of children when kids are attending school, and a 1-year-old doesn't get to decide if they want to participate or not. You get them out of bed, change their diaper, put them in the car seat, and off you go. All right, the court will accept your plea as responsible. And Mr. Roberts, you may approach, please. I'm going to have you stand over at the table there. Please state and spell your first and last names for the record.
My name is Cody Roberts, CODY-ROBERTS.
All right, please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
All right. And sir, what is it you'd like the court to know?
This is the third year in a row that my daughter has averaged 30 to 40 absences and 25 to 30 plus tardies. She was living 4 minutes in between both schools, Wilson Middle School and Garfield, when her daughter wasn't attending the high school. Same story.
Hold on. It can't be 4 minutes between Wilson and also Garfield.
Where she was living at the time was around the Antoine and Lindbergh area. So she was perfectly placed basically in between Wilson.
Right. But I would say 4 minutes because obviously drop off lines and whatnot play a role in that.
And just drive time, basically.
Right.
4 minutes in between both schools.
Okay.
Same issues were happening. Miss Duncan was having a substance abuse issue and was going out and drinking and leaving the children at home on weekdays. I do have proof of that as she contacted me one of the times to hang out at 1:30 in the morning on Sunday. I've contacted CPS about this. I've contacted the school about this, resource officers about this. Nothing seems to happen where then she walks in here and gets $50 fines to what? My daughter's test scores are slipping. She's very, very bright. Actually excelling. She's been testing 2 grade levels above her placement her entire school career. Now she, this year, after missing 40 days of school and having 28 absences, I believe, she has missed all of her test score rules at the end of the year, which she's also very disappointed in herself about and blaming herself, which it's really not. On the days that she does get to school, a lot of the time it's not until 10 a.m. And I have asked the school to document these for me, but it's been 10 plus times that she doesn't show up to school until 9:30, 10 o'clock in the morning.
Okay, ma'am,
There were multiple.
just a moment. Ma'am, is that also happening?
That has happened a couple times.
Why?
She is having a very hard time sleeping because of the things that I mentioned. And so that's what we're working on. But
So why does she know what's going on between you and
because she was there. Because she was there and he tells her what's going on. That's why.
Mr. Roberts is telling your daughter what's going on between the two.
Correct. Yes.
Are you having that conversation with your daughter, sir?
No, Your Honor. My daughter was in the home when she attacked me. And I have
Pause. Just a moment. That's not what I asked.
no, my daughter heard.
My question is, are you having conversations with your daughter regarding the issues between you and Ms. Duncan?
No, ma'am. No.
Not at all. So neither one of you are having conversations with your daughter regarding this, but yet your daughter seems to know what's going on.
She was involved in it. She's been in all of it, and
What do you mean all of it?
she was like present for the incident. She heard her mother scream the thing. She heard her scream and
Okay. All right. That was
Excuse me now.
one time
Yes, no,
That
this
was
has been a
brought-
very toxic.
Just one moment. I don't disagree that it's been toxic between the two of you. However, that was one situation that occurred, I think it was about a year ago that occurred.
Yes.
26.
Or the 28th.
June of 2026. How about we agree on that?
2025, yeah.
I mean 2025. Has there been other conversations with your daughter regarding the other parent, Miss Duncan?
I don't talk to her. I don't. No.
Yes or no?
No.
Mr. Roberts?
Oh,
Yes or no?
yes, in the change of custody, yes.
What does that mean?
My daughter has been asking to live with me for a few years now, and she knows that I am currently in a custody case because of the things that happened. She knows that.
So why does your daughter at 7 or 8 years old know that there's a custody action pending?
Due to the back and forth and the verbal agreement changes that happened when everything.
Sir, your daughter is in the 2nd grade.
I'm very.
There is zero reason why your daughter should have any information as to what's going on between the two of you. Yet you're still talking to her about it.
My daughter is also very in tune, so I don't overexpose her. But if she does ask me questions, I'm not going to just ignore her. I give her the bare base amount of information possible where I go.
Yes, ma'am.
Your Honor, Mr. Roberts purchased our daughter a phone, and through the past couple of years has been using it as a GPS tracking device. What's not being said about what happened is that I'm in the pursuit of the reason why the situation is so contentious is because Mr. Roberts wanted me to get in trouble and I did not. And now I'm working with a detective.
Well, if I recall correctly, the charge was dismissed because Mr. Roberts was not a resident of the property. And so therefore, the force that was used against Mr. Roberts based upon what the prosecutor and defense attorney agreed upon was that you have the right to defend yourself. So that's what that was.
I believe that, as it says in the police report, I believe that a crime was committed by Mr. Roberts during this time. So that's what I'm in pursuit of now. I had written a letter to the court clerk saying that I was not comfortable with him being here today because I have a scheduled hearing for a protective order.
I understand that. I reviewed that email, ma'am.
Yes, ma'am.
And then it was responded to you.
Yes, it was. I'm just explaining why. Because of what's happening in real time.
What I'd like to know is why your daughter knows as much information as she knows regarding these matters. And ma'am, if your daughter is having trouble sleeping, then is she in any sort of therapy or counseling?
She started a counseling program at the school that Mr. Robertson canceled and then restarted. I tried to get her signed up for therapy a couple of times and Mr. Roberts gave false information. So then
Hold on. My question, ma'am, requires a yes or no answer.
Is she now? Yes.
She
at school.
At school.
We have to agree upon outside, and we have not been able to, because he wants to be in control of it and I am her primary caregiver.
You're right.
Well, the two of you have joint legal custody, correct?
Correct.
You're right.
Right. So then the two of you are supposed to work together for the benefit of your child, not worry about who's in control over who.
Correct.
I scheduled a therapy appointment for my daughter at a therapy office after Ms. Duncan had reached out to me and said, hey, we need to put her in therapy.
Hold on. Did you just pick the therapist or did you talk to Ms. Duncan about the therapist?
So yes, she said.
Did you pick the therapist yourself or speak to Ms. Duncan about the therapist?
The text message Rachel sent me said, do you want her
Sir,
to start
it's
your
in your
therapist?
Wait, no, stop. You're trying to give me more information than what I'm asking for right now. Did you select the therapist on your own or did you speak to Ms. Duncan to work out a therapist that you both agree on?
I scheduled her an appointment at the therapist that I was seeing, which is what Ms. Duncan asked me if I wanted to do.
First of all, sir, a therapist that's seeing you and your child separately is a little bit of a conflict of interest, especially.
Office different therapist. I'm sorry. I should have specified. But that's
So,
I'm happy.
did you, I'm going to repeat my question for the 5th time. did you speak to Ms. Duncan about which therapist your daughter was going to
Yes.
go to?
Yes.
You did.
I did.
Ms. Duncan, was there a conversation between the two of you regarding the therapist that your daughter was going to see that Mr. Roberts suggested?
Yes, and I did not agree.
Yeah, okay, so yes is it. Okay, so you did not agree to the therapist. Did you offer another option? Yes or no?
We both found places. I don't remember.
Did you offer another option when you declined the one that
I don't remember. I don't remember because this was a year ago. I don't remember.
She called and canceled the appointment.
Excuse me, I'm not asking for interjections. What I'm trying to figure out is for this second grade child of yours, who I'm being told by Ms. Duncan, is having trouble sleeping, which is one reason why she's missed so many days of school, yet she hasn't been in therapy.
May I explain why the appointment was canceled?
No.
Okay.
No. No. What should be explained to the Third Circuit Court judge who's hearing your custody matter is why in the world the two of you can't put aside your differences with each other and your dislike for each other. I don't need an answer right now. That's for the Third Circuit Court judge. To put the interest of your daughter first. Even right here, for a simple truancy matter. The two of you are each other. Absolutely ridiculous.
What's
absolutely ridiculous.
It's happening now. Harassment, stalking. It's happening in real time. How am I supposed to manage that to get along with a co-parent, ma'am, if it's happening in real time?
Ma'am,
last week
it's done via an app with the Third Circuit Court.
No,
have you requested that? Have you requested that with your Third Circuit Court judge? Have you filed an action?
We have a co-parenting app, but nobody is scheduled to monitor it.
What do you mean nobody's scheduled to monitor it?
There's a mediator option. We don't have a person.
You don't have to have a mediator option. What it does is it makes sure that in the event there's communication that's inappropriate, nobody can delete it. It's in real time being read and done.
We don't have the court when we use app close is what was recommended.
Right. But it doesn't allow it allows for a real transcript, so to speak, of communication between the two of you. That's what it does. That's
Mr.
what it
Roberts
does.
is not following any sort of, he's calling me names and harassing me constantly, Your Honor, on the co-parenting app.
Like
constantly.
What? Like what?
You're a stupid bitch. You're a dumb loser. What have you accomplished in the past few years? You're such a whore.
Are you making those comments? Yes or no?
Some of them, yes.
For what purpose, sir?
She has been repeatedly fired from jobs, repeatedly evicted from places, repeatedly.
Sir. Well, I can understand that may affect your child, right? Those are issues that you bring up in court in your custody hearing. What purpose does it serve for you to send that message to Ms. Duncan? Other than to make yourself feel good, what does that do? It does nothing positive. It exacerbates an already toxic situation unnecessarily to the detriment of your child that she's missing 28 days of school.
It's actually 40.
No, it's not.
Yes, it is. It's 39.
It's more than 3. It doesn't matter. If it's 29, 32, 57, 78, it doesn't matter. It does not matter. At the end of the day, the two of you are doing an extreme injustice to your daughter.
Okay.
Extreme injustice.
I'm working to remedy the situation, Your Honor. I'm trying to remove his custody based on his mental health. So,
How does that Get your child, excuse
Because
me,
he's dangerous.
how does that get your child to school on time?
Because he was no longer affecting the home, coming and picking her up unannounced when he's not supposed to come to my house, threatening me constantly. She is being affected by it.
The time that she's talking about me coming to her house, she left my 7-year-old daughter at home to take her older daughter to school.
So she wasn't late.
But she left
Left a 7-year-old child by
at
themselves.
home in River Ridge.
Locked in the house for
multiple times.
No.
Okay, you know what?
No.
I'm not sure. I don't know. Maybe
This
the
is why I
third.
didn't want to be here.
Excuse me. Maybe, ma'am. It appears though your your child's father is concerned with the educational neglect that's going on with
His
your daughter.
actions and words do not match that, then, Your Honor. They do not. He was forcibly calling her at 9 o'clock every evening and forcing that to happen. And if I didn't, then he blew up my phone and blamed me and accused me of alienation when he was insisting on talking to her at 9 o'clock. So then she was not going to bed, and then she was either late or she didn't go.
Okay,
Now that
just
hasn't been
one moment. Just one moment. Just one moment. Did you insist on talking to your daughter at 9 o'clock at night on the phone? Yes or no?
Yes.
Yes. Okay, hold on. Stop. What is your child's bedtime on a school night, Miss Duncan?
Now, 8:30.
Then what was it?
Well, 9:30 because he was on the phone with her until 9 or at
She
9.
does not have one, Your Honor.
Mr. Roberts, why were you insisting on calling a 7-year-old child at 9 o'clock at night?
We have been doing that for 2 years now. That is when my break at work starts at 9 p.m.
What hours do you work?
It depends. I work a swing shift. Friday and Saturday, I work from 6 a.m. until 5 p.m. Sunday and Monday, I work from 5 p.m. or 6 p.m. to 5 a.m.
Okay, so then why can't you have a 5:30 p.m. call time?
The time that she's talking about is only on Friday nights and Monday nights.
Sunday and Monday.
Those are the only 2 times that I called her at those times.
And then she's
Sundays.
always late on Monday.
She's always
late.
Well, ma'am. Was your older daughter late for high school on Mondays?
Sometimes I don't know. No, because she's not the one that has to.
Well, don't you take them both at the same time?
Yes, I do. The older one's late too. Yeah, she's late sometimes.
Well, if you only get your daughter, if you get Eloise to school 5 or 10 minutes late and you're stuck in a drop-off line at the high school because you're dropping your older daughter off timely, how is she late?
From not leaving the house in time. We live 15 minutes away.
I understand that.
That's all. That's all it is.
But ma'am, that's your responsibility.
Yes, ma'am. And that's why I said that now I already explained in moving forward. Mr. Roberts living in the past. I explained in moving forward that my older daughter has a ride and is not trying to even go to Roosevelt because she's so uncomfortable there in that environment. And so then that means that as of April, then that was no longer a problem for me to have to take my older daughter. Now I have one child to take. She hasn't been talking to Mr. Roberts at 9 p.m. on Sundays and Mondays. And so now she's going to sleep and everything's fine.
3 weeks
And
ago,
so,
she missed all
excuse me,
5 days.
just one moment. Why was it until April that your older daughter didn't have a ride?
Her friend's brother got his license and he is a junior, I believe, at Roosevelt. And so they offered to come and get her because they live close to us. And they offered.
Did you make any other attempts prior to that?
To get her a ride?
Yeah.
No, because we moved to River Rouge and she goes to school in Wyandotte. So I didn't.
When did you move to River Rouge?
In December.
Okay. And so was there a week last week where your daughter didn't go to any school?
No, that's not correct. She's very exaggerated.
She missed one day, went to school at 10:30 one of the other days and had an unexcused absence for the morning and then was tardy the other 3 days.
Okay, so when you said she missed all 5 days, that's what you said.
I missed or was late.
No, that's not what you said.
There has been no.
The two of you really need.
I'm working on it.
What are you working at?
Us not having any communication whatsoever and a third party because that's what we need.
to both grow up.
It's not.
That is what you both
It's not
need.
what has happened. It's not going to happen.
Excuse me. You both need to step off of your current positions, not focus on yourselves and your own frustrations with each other, and focus on your daughter. That's what you need to do. That is what needs to happen.
I'm focusing on defending my son, Your Honor, who is also the father, like Cody Roberts is also his father. So how am I supposed to say that he's not a dangerous person and that I'm supposed to work with him if he almost killed my son last summer? And I'm supposed to just hand him my children, and I'm supposed to be okay with that when he has lied and he got me arrested because I defended myself.
Hold on. So the incident last summer, were there criminal charges filed against Mr. Roberts?
Not yet.
No. I wasn't arrested.
Because my case got dismissed in November, and now I have spoken with Detective Geiger, and I have evidence to turn in, and he said he's going to give it to the Wayne County prosecutor so that we can move forward. But I had to deal with this first.
Why can't you do both simultaneously?
I'm also filed for a protective order, and I'm trying to find a job, and I have 3 kids.
Stop interrupting, sir. Stop interrupting.
I have 3 children. I'm looking for a job. I filed a protective order so that I can get some peace because I'm being harassed all the time.
Ma'am, why can't you turn over the evidence to the detective and still handle this matter at the same time?
All of those things I just said that I do every single day, Your Honor, by myself. I have the information, but he wants a statement as well. So I told him that I needed to take care of, I can't just keep adding to my list. I need to subtract. I'm very overwhelmed.
Did you set up a meeting with him today since you're already coming to court?
No, because I had to make sure that someone could pick up my children from school and I need to go get them. I was scheduled to be here at 2 p.m. and my kids get out of school at 3.
Yes. So did you set up an appointment before 2 p.m.?
No, I did not.
It's happening in real time means.
All of this is happening right now. He's still saying these horrible things. He's still doing these horrible things. It happened last week, days ago. How am I supposed to co-parent with somebody who is trying to make me kill myself? He wants me to eliminate myself, Your Honor.
I told you to go. Like, sort of sign up with kids. I didn't say anything about hurting yourself.
Why? Okay, listen. You all better get it together before you before you go to your third circuit court judge, because they're likely going to remove the children from both of you.
We have mediation coming.
I can see how that's going to go. All right. So what I'm going to do is I'm not going to sentence you on this matter yet. I'm going to have you submit proof of your child's therapy attendance.
Thank you, Rob.
Not the school therapy, because that's going to be ending soon, because school is going to be ending.
Yes, ma'am.
So is there a therapist that your child is currently scheduled to attend outside of school?
No, ma'am. But I did receive a recommendation from Child Protective Services.
Okay. So are you okay with your child going to a therapist suggested or recommended by CPS?
I would like to review the office just to look at, reviews and things like that. But yes, of course, I have not been the one blocking any.
Your Honor, when the appointment was scheduled, Mr. Roberts gave them his address as Eloise's address because he is trying to be completely in control of the situation.
Hold on, pause. Excuse me, just one moment. Just one moment. Do you carry the health insurance for the children?
I do.
Okay. And so then are you listed as the primary
Yes.
party responsible for payment?
Yes.
Okay. So that would make sense in one aspect as to why his address is being used, not necessarily to control the situation or not. I don't know. Stop. Here's what I'm going to do. You're going to send in to me, ma'am, a list of 3 therapists. So you're going to send in a list of 3 therapists, and I will decide which therapist your child is going to go to. That's what we're going to do.
Okay.
So that something can get started while you're awaiting your matter in Third Circuit Court. You're to submit those by June 9th. Now, it's also important that the therapists that are selected are covered by Mr. Roberts' insurance.
You can send her pretty much.
Okay. And then what I'm going to do is I'm going to adjourn to let's do September 23rd. We'll set this for 1:45 p.m.
Okay.
if that works. Ma'am, it's not our intention to have matters delayed for people. I understand that everybody's time is important. And but sometimes the day it takes on a mind of its own that we don't necessarily have control of. So we'll do 9:23 at 1:45 p.m. And by then, we will, there'll be a few weeks into school, so we'll see how that's going. And then we'll see if there has been any resolution in your custody matter with the Third Circuit Court.
Just so you know, Your Honor, our daughter is not included right now in our custody arrangement. Only our son is. They have not combined the cases. So there's not going to be a change.
Hold on. One of you filed the custody action, correct?
The state did.
The state did for support purposes?
Correct.
Right. Okay. And so there's currently a custody and support order for your daughter.
There is both. They were adopted. Basically, they adopted our original custody order for Eloise over to Theodore, but we haven't actually gone to court to,
and there's some separate cases
or any motion to modify for.
The judge has to do that. We don't need to.
Again, only one can speak at a time. But if there's all these concerns, how has there not been a motion for custody filed?
I asked why they have not combined the cases, and we were told we have to wait to see if the judge decides to even do that. We don't have it. We were told we don't have to say it.
Hold on. I'm not asking about combining the cases, ma'am. I'm asking about both of you are alleging that the other is a horrible parent. Yet neither one of you has filed an action for custody.
I already have custody.
Excuse me. For modification of custody.
He did.
Or parenting time.
He requested full custody.
Just one moment. When did you ask that? Or when did you file that motion?
I didn't. When the custody stuff came up for Theodore during this case, I hired a lawyer. I started having him draft the motions. I had him come and represent me. At that point in time, he basically said that we'll just wait until, things are situated with Theodore and then modify custody since they already adopted the custody agreement over. We were supposed to do a motion to modify custody, but I ended up.
Ma'am, are you on your phone?
Yeah. I was just blocking the call.
So you were on your phone.
Yeah.
Your phone's supposed to be off, so you don't have to worry about blocking anything.
I did file, I started to file, and then after representation, we still hadn't filed the motions I wanted drafted, so I ended up firing it. But I am working on having.
When was that?
This was January.
And we're June, and you still haven't filed a motion.
I fired him in the beginning of March, which is
And again, you still haven't filed the motion
because we're in mediation current.
for a different child.
Right, but I'm trying to have everything be done once, not just repeatedly file with the courts and get.
Well, you do realize the case that's pending in the Third Circuit Court is only about one child. They don't have jurisdiction over the other one at this point. So the two of you have to really sit back and list your priorities as it relates to your children. So I'll see you back on September 23rd at 1:45 p.m. Mr. Roberts, you're going to have a seat in here while Ms. Duncan leaves.
Thank you, Your Honor.
Have a good day.
Oh my. I mean, it kind of reminded me of that old The War of the Roses. Anybody ever see that movie? I know a few of you out there have seen The War of the Roses. Kind of reminded me. Well, saw a lot tonight. Saw a guy who might be deported because of one word. One word that he really didn't like being in place on his charging orders. I don't even know how to properly phrase that. We saw a bunch of interesting stories with people in court in Royal Oak, traffic issues. with Judge Urich, or Magistrate Urich. You know, generally we see Magistrate Urich as Prosecutor Urich with Judge Dad. So I wanted to kind of throw him in there. I like looking at. He has some really interesting. The lady who couldn't hold it, kind of funny. I thought the guy with the guy who wanted to use his Uber app as a foil for a radar gun, that was quite interesting to me. And the guy with the very nice background, you know, I can appreciate things like that. But there was a lot more we saw tonight, ladies and gentlemen. And that last one, oh my God, words cannot even say. Mortimer Duke says it correctly. Man, that hurt. Hurt. Ladies and gentlemen, speaking of hurting, I'm just plugging all this up right here. Here's some names. These are really important names. I really respect all these names. That Stephen Furflerberger guy and that Kiernop guy right there. Those people. And Wendy, thank you so very much for being out there. Marty, thank you for being out there. Brecken, I don't care what Wolfbot says. It's probably your fault. Although, for the most part, the very last case was all Felix's fault. He actually sent me a message while I was in the middle of work and said, "Hey, Judge DeSanto is having a day," and she did have a whole darn day. We only had time to look at 30 minutes of it, so that's what we did. The rest is on the cutting room floor. And you know what that means? That means fair game for Saturday, or fair game for a fun song. One of the two. We'll have something in order, ladies and gentlemen. Good night. Good night. Good night. I am your lone wolf Foosville. I do this every single night of the week. Every around 8 p.m., 9 p.m. Eastern. 8 p.m. Central, 9 p.m. Eastern. I don't even know what I'm saying anymore. Come by and hang out with me. I'll have a lot more. Be doing it again tomorrow. Like I did tonight, the night before, the night after. In perpetuity. Feeling 90. Now I'm out. You guys. What? It ended a good 3 seconds ago and you're still here chatting. What? Look, there's nothing down there anymore. Thank you all. I guess all that's left is to say bye. But that's just not a proper outro where I, properly say, "Hey, get out of here. There's no more." This You can go watch like Ferris Bueller's Day. Oh, hey, you don't have to go watch Ferris Bueller's Day Off. We're redirecting over to that crazy wolf bot that is still playing as we speak right now, and I forgot all about it. I should probably even share a link going over to that crazy wolf bot. Oh, wait. Hold on. What did I see here? Oh. No, I'm not doing it. I was going to play something directly from YouTube. I know better. I'm not doing it. We can go watch Wolfie together. So go. I have no more. There really is no more. I don't know why we're still here talking about it. Bye. No, I didn't do it. Bye. No.